Vinit sir, can we start? Vinit sir, can we start? Vinit sir, can we start?
Ma'am, is I'm audible?
Yes, sir.
Okay, so there was some technical issue on my part. I think it got resolved now if I'm audible as well as I'm visible.
Sure, sir.
Okay, I think my video is having the same connectivity issues. Uh, I think my video is not working, but anyways, we can initiate with the session because already a substantial time has been elapsed now. I must say this is a topic which is,
सर एक मिनट मेरे को इंट्रोडक्शन दे लो
मैम बट ये वीडियो दिख रहा है क्या आपको?
सर नहीं आपकी वीडियो नहीं शो हो रही
हाँ ये कुछ anyways, we can start without any further. We should not wait for this technical aspect to get resolved. We can start. In case if I'm audible, we should start.
गुड गुड एवरीवन आई वेलकम यू ऑल of ICSI on the topic pre-existing dispute and need of pre-institution mediation. 9 matters. Today we have with Mr. Vinit Nagar for taking session as a speaker. Let me briefly introduce Mr. Vinit Nagar. Sir is a lawyer, practicing company secretary, insolvency professional, having an overall post-qualification experience of approx 13 years. He is a founder of Mr. Vinit Nagar and Company secretaries. His core areas of practice includes commercial and corporate litigation. He regularly appears of enforcement, ROC, RD. He has advising his clients on the issue relating to the corporate laws, insolvency and bankruptcy law. He holds an immense expertise in handling the matters such as shareholder management dispute, removal of statutory auditor, removal of director, merger and amalgamations, adjudication of penalties, compounding, handling inquiries, inspection and investigation relating matters under the Companies Act, restoration of name of stock, striking of companies, representation of behalf of debenture trustee, debenture trustee before quasi judicial firms, support services in the matter of corporate insolvency resolution process and liquidation. Sir, you may now start the session.
Thank you, ma'am. Thank you very much. The video setting is having any problem, but anyways, we should start now. As far as Section 9 is concerned, I must say this is one of the area wherein mediation or the provisions of the Mediation Act should should be enforced, or should be, the regulation should come in between, and through such regulations, such applications required some governance. Now, why this is so? The reason is the pre-existing dispute has created many disputes. I've seen many of the disputes now being raised by the corporate debtors are illusory in nature. But since it is a dispute which is raised prior to the service of demand notice, such applications are not getting the requisite adjudication, or such applications are being rejected on the grounds of the pre-existing disputes without, because the adjudicating authority being a summary in nature, this proceedings being a summary in nature, they don't go into the root cause, they don't go into the merits and demerits of the disputes, and they are just, they generally try to dispose of the application against the operational creditor on the grounds of having a pre-existing disputes. Now, this pre-existing dispute very well indicates that there has to be some existence disagreements, and such existence of disagreements or a dispute need to be prior to the service of demand notice. Now, the corporate debtors are getting literate. The corporate debtors have understood the benefits of raising issues through email or through any other mode of communication, so that they can take the best benefit of such communication at the time when any application is made against them before the NCLT. And as I said, that the proceedings are summary in nature, and the NCLT don't go into the root cause, or they don't go into the legitimacy of the issues, and they generally passes an order against the operational creditor mentioning the fact that there being a pre-existing disputes, and hence this application is liable to be dismissed as rejected. Now, my point is, we will certainly discuss that how mediation is going to be a helpful tool to get an early disposal of Section 9 application, how mediation can going to be, or in what sense. See, there is always a debate, because mediation is a voluntary act. Now, you cannot impose a condition on the parties to opt for a mediation before they move an application before the adjudicating authority under Section 9 of the IBC. As far as the Mediation Act is concerned, we are going to certainly deal into those provisions. But before I jump into that part, I would like to initially discuss the things with few aspect, would like to share the things with few practical examples, or few practical experiences which I have seen, that even though there was a merit in the case, even though the application which was otherwise eligible to get admitted has got rejection, or has got dismissed on the grounds of this pre-existing disputes. I'm just sharing one of the matter wherein I was representing the operational creditor, and the application got rejected, the application got dismissed on the grounds of pre-existing dispute, in spite of the fact that there was no pre-existing dispute. And this is what I said, that the word pre-existing dispute has made many disputes. And again, I would like to repeat the same thing, that now our corporate debtors are getting the necessary advice or are getting necessary instructions or are getting necessary consultations from the experts or from the insolvency practitioners, that how this early communication with regards to, or how this raising of quality issue or raising the issue pertaining to the amount or raising an issue pertaining to the quantity is going to help them out in future in case if the operational creditor tomorrow go against them before the NCLT for initiation of CIRP. As far as section 8 is concerned, the provision of section 8 is very clear, which talks about a pre-existing dispute and the dispute which exists prior to the service of demand notice. So, meaning thereby a communication which is subsisting or which is existing before the date when a corporate debtor has received a demand notice, that are generally referred as or they are generally classified as a pre-existing dispute. Now, as far as the legitimacy of that dispute is concerned, that is always in question because they don't go into the root cause, they don't go into the merits and demerits of those communications. The NCLT don't go into the merits of the case on the basis of which uh, that communication was exchanged between a corporate debtor and operational creditor, but just because of some communication which is existing prior to the date when the corporate debtor has received a demand notice, the application generally go against the applicant. The outcome of the application go against the applicant, and that is just because of there is a communication which is subsisting prior to the date when the demand notice was delivered to the corporate debtor. Now let us see, first of all, let us go into the definition. Let us go into section 8, section 9, and I would like to share with you a recent matter which I have handled, which unfortunately goes against me. We are before the adjudicating the appellate authority, and let's see the appellate authority what outcome the appeal is going to bring it to the operational creditor in that case. But let me share the screen so that we can at least have that pre-existing section 8, section 9, and then we'll see into the provision of mediation as well. And before that, there are few recent examples which I've seen or which I've witnessed, or wherein I was one of the counsel representing both the cases I'm going to share. One wherein I was representing as an operational creditor, and other wherein I was representing a corporate debtor as well. I hope the screen is visible to you. Is it visible? Whether the screen is visible to you or not?
Yes, it's visual,
Yes,
sir.
sir, it is visible.
Thank you, sir. As far as dispute is concerned, it has made it very clear that the suit or arbitration proceedings are not mandatory requirement to establish there is a dispute, because it is very clearly stated that dispute includes a suit or arbitration proceedings, and it is an inclusive definition, meaning thereby a dispute which includes a suit or arbitration proceedings which is pending before an appropriate forum, that is of course going to be a case wherein no such application is going to be, or no section 9 application is going to be considered on grounds of merit because of the pendency of the suit or the arbitration proceedings. But now when it says it is inclusive definition, so as far as this inclusive definition is concerned, the dispute is confined to the existence of the amount of debt. So meaning thereby any amount or disagreement in terms of the amount between a corporate debtor and operational creditor that may tantamounts to a differences, or that may tantamounts to a dispute as far as section 9 IBC is concerned, or as far as section 8 IBC is concerned, or as far as dealing with section 9 application is concerned. The quality of goods or services, now there is again, we have seen many of the issues wherein one of the lot is rejected by the corporate debtor on terms of the quality of the goods or the quality of the products being delivered, or there is some deficiency on the part of the corporate debtor in terms of the services which it has received from the operational creditor, or the operational creditor has rendered certain services which has been questioned by the corporate debtor, or there is a breach of representation or warranty on the part of the operational creditor. So this is what basically the dispute in relation to section 5 clause C is concerned. And as I said, it is very clear that it is an inclusive definition, meaning thereby if pendency of the suit is there, or if any pendency of the arbitration proceeding is relating to any section 9 application, no section 9 application will reach to its finality, and it will be rejected on this very threshold that there is a suit or there is an arbitration proceeding which is pending between the parties before any appropriate court, or before any appropriate tribunal, or before the you can say this arbitration tribunal. But since this being an inclusive definition, meaning thereby we have seen many of the judgments which are being passed against the operational creditor on the very grounds that there was a communication which indicates that there was some dispute which was existing in terms of the amount of the debt, or in terms of the quality of the goods or the products which has been delivered or which was delivered to the corporate debtor, or in terms of the services which been rendered to the corporate debtor, or in terms of any representation, or there is a breach in terms of the warranty by the operational creditor. Now as far as section 8 is concerned, it is very clear that there has to be an existence prior to the receipt of demand notice, and this is what section 8 all about. When you see the provision of section 8, it states that an operational creditor on occurrence of default deliver a demand notice of an unpaid operational debt, including a copy of the invoices. So when I will be serving a demand notice, I will be serving a copy of the invoice demanding a payment of the amount which is involved in the default to the corporate debtor in such form and such manner as may be prescribed, which we can see in the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016, and there is in Form 3, Form 4 is prescribed. The corporate debtor shall, within a period of 10 days of the receipt of demand notice. So, again, we know that this period of 10 days is again not a mandatory and again a directory. So, this kind of dispute may be raised later, later this kind of reply may be served even after the expiry of 10 days. So corporate debtor shall, within a period of, in spite of having the provision which states that it is the shall, the corporate debtor shall, within a period of 10 days of the receipt of demand notice or the copy of invoice mentioned in subsection 1, bring to the notice of the operational creditor about the existence of dispute, if any, or record of pendency of the suit or arbitration proceedings filed before the receipt of the notice or invoice in relation to the dispute. So this is very important thing, that it is the corporate debtor who need to bring this kind attention in response to the demand notice which has been served to it about the existence of dispute or record of pendency of the suit or arbitration proceedings before the receipt of the notice or invoice in relation to such a dispute, or else the corporate debtor has to prove that the payment against which the demand notice is served has already been paid by sending an attested copy of the record of electronic transfer of the unpaid amount from the bank account of the corporate debtor, or by sending an attested copy of the record that the operational creditor has encased the check issued by the corporate debtor. As far as explanation is concerned, it clearly states that demand notice means a notice served by the OC to the CD demanding payment of the operational debt in respect of which the default has occurred. Now, as far as Section 8 is concerned, it clearly states that it is the prerequisite before you invoke Section 9. It is one of the pre-requirement before you opt for Section 9 against a corporate debtor, and that states that you need to serve a demand notice. You need to enclose the invoices which you are relying upon, which are being categorized as the invoices which are unpaid or in default, and that notice you need to serve to the corporate debtor at its registered office, or to KMPs you can also send through an email. So this is what is provided in the insolvency and bankruptcy application to adjudicating authority rules 2016. But the point here is subsection 2, which states that within a period of 10 days of the receipt of demand notice, it's a corporate debtor who bring to the notice of the operational creditor about the existence of a dispute, if any, or pendency of the suit or arbitration proceedings before the receipt of the demand notice. Now, this is very important, and this connection only, when you see provision of section 93B, when you move an application, you need to give an affidavit whether any reply was received in response to demand notice, or when a dispute was raised by the corporate debtor in response to the demand notice. And that's why you will find 93B affidavit in every section 9 application, which states that an affidavit to the effect that there was no notice given by the corporate debtor relating to the dispute of unpaid operational debt. So you need to state whether you have received response, whether any notice was given by the corporate debtor in response to a demand notice or not. And that's why when you see 93B affidavit, it is an affidavit which is provided by the operational creditor to the effect that there is no notice given by the corporate debtor in relation to the dispute of unpaid operational debt, in case if it is your case. Otherwise, when you see the provision of section 9, it clearly states that on expiry of the period of 10 days from the date of delivery of the notice or invoice demanding payment, if the OC does not receive payment from the CD or notice of dispute under subsection 2.8, the operational creditor, now it is very clear that if the OC does not receive a payment from the CD, or if the OC does not receive a notice of the dispute, then only an operational creditor may file an application. But many a time it happens when a CD is responding to the demand notice, then also OC is moving an application before the NCLT for initiation of CIRP, and there it comes the role of the NCLT. But again, as I said, the proceedings being a summary in nature, and that's why generally if any notice was sent by the CD in response to the demand notice, and if the CD, if any notice was served by CD to the OC in response to the demand notice, and if the CD has proved that there was some differences or there was some issue in terms of the amount of the debt, or if there was an issue in terms of the quality of the goods or the products, or there was some issue pertaining to the service been rendered to the CD, or there is an issue pertaining to breach of the representation or the warranty, in that circumstances, that reply to the demand notice makes many things comfortable as far as the interest of the CD is concerned. And that's why when OC moves an application, such an application, along with the application, the copy of invoice demanding payment that is required to be attached, affidavit to the effect that there was no notice given by the CD in relation to the dispute of the unpaid operational debt, a copy of the certificate from financial institution. ठीक है, that is not a part and parcel of our discussion that what shall form a part of section 9 application, but this is something which is very related. And when you see subsection 5 of section 9, that states that the adjudicating authority shall within 14 days of the receipt of the application under subsection 2 by an order admit the application or reject the application. It may admit the application if no notice of dispute has been received by the OC, or there is no record of dispute in information utility. Meaning thereby, it is always a prerogative on the part of the CD as well to record the dispute in the information utility. But many times I've seen, when you see Form D is generated when a debt is, the authentication process pertaining to lodgement of default gets completed. You must have seen in many of your cases as well, or you must have seen in many of the cases which you have studied, wherein the dispute was raised, and dispute was raised prior to the issuance of, or prior to the delivery of demand notice, but during the debt authentication process initiated by the OC through NESL, the corporate debtor has not disputed the debt, and Form D status is deemed to be authenticated. Now there is again, because when the NESL report states that the default is duly acknowledged or authenticated and there is no dispute over the amount of default lodged by the operational creditor with the NESL, there is always a question which comes before the adjudicating authority, that if the dispute was real and it was not illusory or it was not hypothetical, then in that case, why that during the course of authentication process, why the CD has not raised the concern before the NESL, and why the status of the NESL is deemed to be authenticated. Generally the status of the NESL makes a big difference, and the status of NESL always gives an extra age to argue the case, that if the dispute would have been a real and not illusory, the CD must have raised certain objection during the course when the NESL has initiated the inquiry in terms of a debt authentication process. Generally, what NESL do, NESL used to serve an email to the corporate debtor asking for the representation, if any, against the default so lodged by the operational creditor. So this is again very important, that the NCLT is going to admit the application in case if the application is complete, there is no payment of the unpaid operational debt, the invoice or the notice for payment to the CD has been delivered, no notice of dispute has been received by the OC, and there is no disciplinary proceedings pending against the IRP whose name is proposed, which is not mandatory in Section 9 application. But if any name is proposed, make sure there is no pendency of disciplinary proceedings. NCLT may reject the application and communication such Ds into the operational creditor if the application is incomplete, or there has been made a payment made by the CD to OC, or the creditor has not delivered the invoice demanding, or that demand notice was not delivered to the creditor, or there was a notice of dispute has been received by the OC, notice of the dispute has been received by the OC, or there is a record of dispute in the information utility. Now, this is something which is, as I said, the notice of dispute has been received by the OC, rather, or it should be, and there is a record of dispute in the IU. Because of this, or NCLT again gets some sort of discretion to favor the corporate debtor because of this word, or the notice of dispute has been received by the OC, because in many of the cases you will find that the notice of dispute has been received by the OC, but during the debt authentication process of NESL, the CD has not raised any dispute, and there was no record of dispute in the repository of this IU. So in the records of IU, there is no dispute in terms of the amount of default which has been lodged by the OC, but otherwise the OC has raised an objection, or OC has raised a notice to the fact that there is a pre-existing dispute. But because of this clause D, which you can see in section 9 subsection 5 subclause 2, and you will find this in clause D, that notice of dispute has been received by the OC, or there is a record of dispute in the IU. And that's why you will find not both the things are going hand by hand. You will find that there was a notice of dispute been received, but there was no record of dispute in the IU, and vice versa. The CD has raised dispute during the authentication process of NESL, but CD has not filed its reply to the demand notice when it has received the demand notice, and no such kind of communication was made in terms of the existence of any pre-existing dispute. I would like to share a very recent matter which I have dealt before the NCLT Ahmedabad bench. So I was representing the operational creditor in that application, and my client was the supplier of coal. So it was the imported coal which we used to get from Indonesia, and we used to supply that coal to the corporate debtor. It happens during the course of this commercial transaction, it happens the quality is not in line with the requirement of the OC. Many a time it happens, not all the trucks, but some of the trucks which are not meeting the or which are not matching up with the requirement of the OC, but still requirement of the CD. But CD kept on placing the order, and I believe that if the corporate debtor is keeping on placing the order, keeping on accepting my goods, keeping on consuming my goods, and keeping on processing the payment, then in that circumstances one cannot consider that communication as a communication which should give an age to a pre-existing dispute, because it is always presumed and assumed that this is just a normal business communication which generally get exchanged between the parties during the course of any commercial contract. What happened in my case, it was in the month of it was in the month of June 2014. We have served demand notice to the corporate debtor. In the month of June 2014, the demand notice was served. Yes, we have received a reply to that demand notice within a statutory time frame of 10 days. And in response to a demand notice, the corporate debtor has attached one email. The corporate debtor has attached one email dated 4th April 2014, wherein the corporate debtor has mentioned about some trucks since 2021 till 23. My last supply was in the year 2023. I served demand notice that is in the month of June 24. In response to the demand notice, the corporate debtor has responded to that demand notice mentioning one email, and that was the only email ever received from the corporate debtor. That was the only email which we have received from the corporate debtor, and there is no communication in the email from the very first transaction till the late date of last transaction. But that email of 4th April 2024, in that email, nothing in the body of the email was written. But in annexure to that email dated 4th April 2024, there was a sheet which was attached in that email mentioning that इतनी ट्रक्स हैं, इतनी क्वांटिटी है जो कि inferior नेचर की थी. So in that email, there was one Excel sheet which was attached, and in that Excel sheet, the corporate debtor has tried to establish that till date, since 2021, these are the trucks on which the other side has alleged that the quality of those material referring to this lorries or this trucks were inferior in nature. But otherwise, we have received, the corporate debtor has referred to somewhere about 37 to 38 trucks, which he has claimed that the quantity was not the quantity was not, or the quantity of the supply which was mentioned in the invoices against those supply, is not in accordance with the quantity which are stipulated in the invoice. Furthermore, the quality of that coal was not of consumable, or quality was not best suited for the manufacturing process. But this was the only email, and the email which we have received from the CD, that was in the April 2024, mentioning all those lorries, mentioning all those trucks which were supplied to the CD since 2021. And in response to that email, there was no further communication ever been exchanged by the OC as well. So basically what happened, when we moved section 9 application, in section 9 application I have demonstrated that yes, the demand notice was served, and we have received a notice, we have received a reply to that demand notice. And in reply to that demand notice, the corporate debtor has raised a dispute, but we have challenged that dispute, calling it as an illusory, or calling it as an hypothetical, or calling it as an afterthought. The reason behind calling it as an afterthought is because if there was a genuine issue in terms of the quality, there has to be a communication at that relevant point in time. So there was no communication at that relevant point in time. Now, what is a relevant time? We refer to the provisions of the Sell of Good Act, or we refer to the provision of the Contract Act, or we refer to the provisions of the MSME Act. We relied upon the provision of the Indian Contract Act, or we relied upon the provisions of the Sell of Good Act, or we relied upon the provisions of the MSMED Act, that within what time the dispute, if any, is required to be raised, especially in terms of the quality of the goods, or what is a duty in such circumstances of a buyer. So Sell of Good Act provisions we relied upon, and we have clearly stated that post their consumption, or post its consumption, and post making payment to such invoices, now there is no scope that the dispute can be raised at this belated stage. So the pleadings in that application was completed. In the course of the pleadings, or in reply to that application, the corporate debtor has also relied upon certain WhatsApp conversation which were exchanged during the course of those commercial transactions. In reply to that application which we preferred under section 9, the corporate debtor has also attached certain photographs, and the corporate debtor has attached certain WhatsApp conversation, some photographs and some videos which were exchanged during the course of the commercial transaction. Some WhatsApp conversation, or some WhatsApp communication was also attached in reply to that section 9 application, and we filed rejoinder to that. And we have very clearly stated that the trucks which the corporate debtor is claiming as carrying inferior quality of the goods, or the trucks which are being referred in the WhatsApp conversation, or the email which the corporate debtor is relying upon, the only email which the corporate debtor is relying upon is containing, or is consisting of those invoices which has already been settled and which has already been paid by the corporate debtor itself. And those invoices are not the subject matter of section 9 application. And we have also made the things very clear that why this WhatsApp conversation should not be taken on record in absence of that mandatory certificate under Indian Evidence Act. We have also demonstrated that why this communication was actually required between a corporate debtor and operational creditor, and not with one of the partner to that operational creditor, because those WhatsApp conversation was between a corporate debtor and one of the partner of, or one of the director of the operational creditor. That communication has never been exchanged with, that communication was not exchanged with the operational creditor. Rather, that communication was between that director of the corporate debtor and the other director of the operational creditor. So we relied upon several provisions of the law, and we relied upon certain judgment as well. And we have stated that this is a normal course of communication, and this happens in any commercial transaction. Because if there would be any, or if there was a serious dispute, then in that circumstances the CD must have stopped placing the order, or CD must have been stopped making the payments, or CD must have, or because in the reply, the corporate debtor has admitted this fact that I was the exclusive supplier. The corporate debtor has admitted this fact that during the entire transaction, I was the only supplier to that corporate debtor. So corporate debtor has accepted goods, the coal only and exclusively from me only. So there was no any other vendor to that corporate debtor. I was the exclusive supplier. Now this is something which is blowing both hot and cold, because on the one side, the other side is claiming, the corporate debtor is claiming that I was the exclusive supplier. On the other side, the corporate debtor is also claiming that I was continuously selling them inferior quality of goods. On the one side, the corporate debtor is claiming that because of the inferior quality of goods, the production process has been impacted. On the other side, the corporate debtor has kept on making payments. On the one side, the corporate debtor has claimed that the issue pertaining to the quality was time to time raised between the parties, or the communication in this regard was time to time made to the director of the operational creditor, but to the contrary, they kept on making payment from time to time. So meaning thereby, if there is a genuine concern in terms of the quality of the goods or the products which I'm supplying to the CD, this communication should have been raised at an appropriate time. This communication should have been raised to the appropriate party, that is an operational creditor itself, and you must have stopped making payment to me, or you must have chosen some other vendor, you must have chosen some other supplier with regards to the products which I'm supplying. Now, very interesting, the corporate debtors only relied upon that one email, because that was the only email conversation which was subsisting between the parties to party. Because whatever are the WhatsApp conversation which the corporate debtor has relied upon, that WhatsApp conversation was between a director of the CD and the director of the OC. It was not between a company to company. The CD has never communicated that particular concern pertaining to the quality to the operational creditor. Rather, there was just a WhatsApp conversation which was subsisting, and which generally subsists during the course of any commercial nature of contract. See, we being a company secretary, or we being a chartered accountant, used to communicate with the client. Many a time client raise a concern, and many a time we respond to such concern as well. But that cannot be treated as a dispute. It's a normal course of communication between the parties during any commercial nature of transaction once subsisted between the parties. Now, in my case, it is very important that the only email which we relied upon, that email was received to me on 4th of April 2024. But on the very same day, 4th April 2024, the CD has also made some payment to me. Now, this is very important, and this is very interesting as well. 4 तारीख के एक ईमेल को जो रिलाई किया जा रहा है, that there was subsistence of dispute between the parties. The basis of establishing a pre-existing dispute is one email which was served to me on 4th of April 2024. But on the very same evening, on 4th April 2024, I have also received some payment from the CD. The OC has received an amount of rupees 10 lakh from the same CD. Now, my point is, once the guns have been raised, there is no reason making payment. एक बार बंदूक उठ गई, उसके बाद किस बात का पेमेंट? अगर ये जेन्युइन इशू था, या अगर ये डिस्प्यूट एक रियल डिस्प्यूट था, द अमाउंट, or rather amount, the quality of the supply was actually a genuine concern, then there was no purpose with the other side to make any payment. So on the fourth morning, the CD is sending an email to me mentioning those trucks of 2021, 22, 23, the time which is gone, the amount which I have received, and the material which right now is in question has already been consumed. and I've received the payment. And those invoices are not even a subject matter of concern in my application. These are not at all a subject matter of default. You have made me the payment, you have consumed my goods, and now you are relying upon that email. And on the very same evening, you are also sending me an RTGS of rupees 10 lakh. And not only on that day, on 11th April as well, I am receiving an amount of 6 lakh from the same CD. Now, my point before the adjudicating authority was very limited, as I said, that this is an afterthought. And even though if it is an afterthought, the moment on the same day if the CD is making a payment, and after a week also the CD is making a payment, this should not be treated as a dispute. And more especially, he is relying upon the quality of the goods which he has already consumed, and he is also relying upon those invoices which are settled. And the other unsettled invoices which he is claiming, which are of inferior in nature, but still he has decided, or he kept on making the payments, or he preferred to make the payment even after the service of that email to me. Now this was the proceedings. The NCLT Ahmedabad bench has directed parties to explore the possibilities of settlement and adjourn the matter. So no settlement reached within a week, and in the very next hearing, the CD has again made a point before the adjudicating authority that they still want to explore the possibilities of settlement, which I objected, which the OC has objected on the very ground that there is no action initiated, or there is no initiative from the CD which they are claiming before the tribunal that they are still willing to explore the possibility of settlement, but there was no settlement, or there was no settlement intent from the other side. We have never been approached by the CD out of the tribunal that they have shown any intent of settlement. And what happened when this matter was listed for the next final hearing, a day before the date of final hearing, the CD has filed an interlocutory application. Now this this matter will be more interesting now. Just a day prior to the final date of hearing, the CD has served me an advance copy of the interlocutory application, which was also listed on the very next day. And in that interlocutory application, the CD has placed on record certain lab reports. Now, this is more interesting. Now, this were those lab reports. I said this were those lab reports which has never been communicated to the operational creditor at any point in time. And my limited point was, if there was an actual concern, or if this lab reports is actually pertaining to that period when the supply was accepted and report was generated, then this report should have been communicated to me, to the operational creditor at that relevant point in time. For example, in Gujarat, there is one city, Rajkot. So suppose if I'm making supply from Rajkot to Rajkot only, it is intrastate or intra-city as well. The operational creditor is sitting in Rajkot, the corporate debtor is sitting in Rajkot, the supply is being made to the Rajkot, report is being generated from Ahmedabad, which is not within the Rajkot, it is altogether a different city, a miles away from Rajkot. So they are preferring to get a lab report from Ahmedabad. The CD is opting for getting a lab report from Ahmedabad, in spite of having this much hardship, or in spite of showing that much concern in terms of that, yes, at that relevant point in time they have opted for a lab report or they opted for a report from a laboratory, but that report has never been a part and parcel of any communication existing prior to, and that communication pertaining to lab report was not at all subsisting. That means at no point in time the corporate debtor has ever exchanged any report to the operational creditor. Furthermore, it was also established that that laboratory was not NABL accredited laboratory. The laboratory was not NABL accredited laboratory. That means casting a doubt on the reliability of that laboratory or the report as well. Furthermore, the corporate debtor has relied upon certain opinions as well. Now, how opinion can be a part and parcel on which the adjudicating authority is going to decide about any pre-existing dispute, and all these papers were an afterthought. All these papers have been actually generated in between the hearings only, wherein the other side has sought an adjournments on the face of exploring the possibilities of settlement, but on the contrary they were trying to generate few opinions. They were trying to generate certain reports from XYZ laboratory, and they have placed those laboratory reports before the adjudicating authority in form of an IEA. Now, this is a submission of some additional papers, which were not forming a part of the pleadings, which were completed between the OC and CD. But they tried to establish their claim by placing on record this report, placing on record this opinions from the expert, and my objection to that effect was very limited, that if this report were generated at that relevant point in time prior to your consumption of my goods, then why no concern was raised to me at that relevant point in time? जब आप रिपोर्ट ले रहे हैं, जब आप इतने विजिलेंट हैं कि you are getting my product tested, you are getting report, and you are getting an adverse report which is questioning the quality of my goods or quality of my coal or product, then why that report has never been communicated to me at any point in time? This was my limited concern. Now you won't believe, this application went against me. This application went against me on this very fronts. One, because there was a pre-existing dispute. What is the basis of that pre-existing dispute? Because the CD has sent an email on 4th April 2024, which is prior to the date of demand notice, which was served on June 2024. On this very front, the application got dismissed. Point two, why the application got dismissed? Because the CD has placed on record certain WhatsApp conversation not exchanged by the CD to OC, but exchanged between the director of the CD and the director of the OC, wherein certain invoices or the quantity or the quality of the goods qua certain invoices were questioned by the CD to the OC, but between a partner of the CD with the partner of the OC. But again, these were those invoices which were settled and not a subject matter of the adjudication. That was not subject matter of dispute. That was not a subject matter of default. Those invoices were settled. And in the email as well, in the email which were relied upon by the CD, out of 37, more than 30 invoices were paid. All the supply against those invoices were consumed. No communication subsisting in terms of the quality or the quality being questioned by the CD to OC. Not a single email. Not a single communications was subsisting. That was the only email which the OC has received from the CD, and that was on 4th April 2024. Not a single email prior to that, in spite of having into this business transaction since 2021. In that email dated 4th April 24, the CD has relied upon those supply which were made in the year 2021, the invoices which were settled, the products which were consumed, and the amount I have received, it is not even a part and parcel of my Section 9 application, not a subject matter of default. And furthermore, the NESL authentication process was favoring me. So, Form D generated by the NESL, outcome of the entire authentication process, the status of that Form D was deemed to be authenticated, meaning thereby during the entire authentication process of that debt and default, there was not a single communication ever been raised by the CD to the NESL raising a question in terms of the amount of default which I have lodged with the information utility. That the Form D which gets generated after the completion of the authentication process was in my favor, which states that deemed to be authenticated, and that was no question ever been raised by the corporate debtor questioning my supply, questioning the quality of my supply, quantity of my supply, or the amount of the debt which was in default. But in spite of all those factors, in spite of having all these parameters, placing the submissions of both the side, the application got rejected on the very ground of pre-existing dispute. Now here my question is, pre-existing dispute, if it is only pertaining to an existence of communication before demand notice, if only things to be seen is there is any communication subsisting before demand notice was delivered, and if the merits and demerits of that communication is not going to be seen, is not going to be touched upon, in that circumstances the corporate debtor will keep on taking the benefit of having this adverse communication, or the CD would always prefer to send certain emails, or CD would always prefer to raise time to time a quality concerns to the corporate, to the operational creditor, so that tomorrow in case if CD fails to make payment, CD can take the benefit of its own email, or CD can take the best benefit of its own deliberate communication, which were made with an intent that tomorrow in case if OC goes against me, I can at least take some benefit of the communication which once I exchange to the OC by naming it as a pre-existing dispute. Now their mediation provisions of the mediations are going to be very helpful, because I've seen in section 9 application in my case itself, for three consecutive back-to-back hearings, the CD has only stated one thing, that in spite of filing this reply, in spite of filing this IA, in spite of raising this objection, I still want to settle. I was knowing that was a deliberate statement. I was knowing that because of this, on the grounds of settlement, he is getting adjournment by adjournment. And during the course of those adjournment, he was just trying to collate the papers from various agency which was going to, or which has helped him out in filing that IA. But that was all an afterthought. That was all a thought process which fortunately helped him out. But my point is, during the course of Section 9 application, why there is a question of settlement, or why, and because at that time entire hope gets dusted. The reason is, if I have raised the gun by serving a demand notice, and if I have already shoot him by making an application under section 9, that is not a right stage wherein the settlement may take place. Yes, it may take place, may not. But I feel that prior to the application under section 9, if there is a pre-institution mediation, if there is a pre-litigation mediation, if parties may even voluntarily opt for pre-litigation mediation, the success ratio of early disposal of Section 9 applications will be very high. And thereafter, there will be no scope which will be left available with both the parties to seek any adjournment on the very grounds of settlement. I will appreciate your views, if any, because you all are learned practitioners who are practicing as an IRP, RP, liquidator, bankruptcy trustee, and you must have faced such issues while dealing with your own application. You must have faced the similar issue while representing an OC, or you must have faced the similar issues while representing the CD. I will appreciate your views before we actually goes into the provisions of the Mediation Act, but my point is very limited that I will appreciate your concern because I've seen Section 9 applications are not are not getting, or Section 9 applications on just on the very ground of pre-existing disputes, the Section 9 applications are not being entertained on merits, are not being concluded on merits, are not being adjudicated on merits, just because the summary proceedings in nature. The adjudicating authorities generally avoid going into the root cause of the dispute, or avoid reaching to the legitimacy of dispute, or avoid reaching to the intent of such communication or dispute, and they generally passes an order which many a times goes against a Section 9 applicant, or which generally favors a corporate debtor, especially in such Section 9 application. I'll appreciate your views, if any, so that at least we can have some interaction on the subject, and before we reach to that, why mediation to be made mandatory for Section 9 at least. Yes, please. I thought there is some question in chat box, but it was just in attendance. I'll appreciate it if, in case, if you can share your experience in this regard.
Sir, I have a question. This is Anita. I have a question.
Okay, ma'am, please.
See, basically, in one of my case, in fact, the OC has sent a mail, meaning sent a demand notice, and there was a reply, and that reply was kind of this thing stating that there was a dispute. But he has sent a mail. That kind of a mail is not at all available with the OC. And second, basically, if anything regarding the quality or quantity after sending the demand notice, generally we will not be considered. It should be a pre-existing dispute.
Absolutely. It should be in existence prior to the receipt of demand notice. Yes.
Okay, so what happened is like since it was created one, we have not received anything, so we filed the case. Finally, we won the case. But I have one doubt. I need a clarification. While you are deliberating this kind of an issue in respect of IU, along with there was a demand notice wherein the CD has uh, like he has raised a question in respect of the dispute. However, when the IU was filed by in IU, the OC filed, there was no dispute raised by the CD because maybe because of the ignorance, or maybe most of the time what we have seen is that CD is not responding when they receive a mail from NS
Yes, sir.
we have seen it, NESL, sorry. We have been seeing it. Under the circumstances, you are saying that which will prevail over? Rather, I would like to ask you this question. It is yet to come. Information utility is yet to come. That's one thing. Second is like there was a dispute raised by this particular gentleman. It was pre-existing. However, in IU, he has not said anything. He
And
was
that is
saying
what my
something in that
point is.
area.
I have already raised my concern in this connection. Section 9, when you see the provisions of Section 9, which I would again once again would like to share, and why there is a requirement to have word and in between rather than having word or. Let me share. I was with section 9. I was in section referring to section 9, subsection 5. This clause to reject the application and communicate such reason to the operational creditor and the corporate debtor if, here I am, the notice of dispute has been received by the OC and rather or it should be and there is a record of dispute in the IU. Both should run hand by hand, so there should not be any it cannot be that there was some kind of communication which was served by the CD in response to the demand notice served by the OC, or there is a record of dispute in the IU, but since there was no any reply to the demand notice, there has to be a cognizance from the operation from the corporate debtor that he should establish that there is a dispute which is in existence prior to the date on which he has received the demand notice, and he has also questioned the lodgement of or questioned during the process of authentication of the debt in default during the course of authentication process initiated by the OC. He has raised the concern, he has raised the communication, and therefore the status of that default is not authenticated. That is in dispute. I must say that there has to be word and in between so that it can assess the NCLT being an adjudicating authority to early dispose of such application. The word is or is creating more trouble. As I said in my case, yes, I have received a reply to that demand notice. In response to the demand notice, in my case, the corporate debtor has relied upon that email. But during the process of that debt authentication process, which was initiated by the OC through NESL, in the entire because there is a three reminder email which has generally been sent by the NESL to this to the CD. CD has never questioned. It is out of his ignorance or out of his unawareness about this process, but he has never objected to that authentication process initiated by the OC through NESL. And because of that inaction, or because of no timely action on his side, the status of the default was deemed to be authenticated. And in spite of having the status, or in spite of having Form D on record, which was indicating that the status of default is deemed to be authenticated, the application went against me. So I believe it should not be or it should be and. What's your say on this?
I completely agree with you. That makes really a sense. Instead of or, if it is an and, it makes the sense. And second, see, basically, most of the areas I have been seeing people, corporate data,
Hmm.
technically, 99% ignorance, lot of ignorance on NESL emails. There is 3 reminders. What you have said is absolutely correct.
But
However,
why?
there
But
is no education, especially in this respect, because people are not taking that much serious.
but they have the seriousness of raising dispute in
Yes.
response to the demand notice. Then why there is no seriousness on the part of NESL authentication? And if there is no seriousness on their part, make sure application should go against them then.
I absolutely agree with you, because people still they are taking little bit light when any intimation from the
And
other
again,
agencies
if
communicated.
this
Yeah,
is
I completely agree with you.
if that does not carry any weight, in spite of if I'm placing Form D on record, which is indicative of this fact that it's a deemed to be authenticated, and still this Form D being a mandatory document, now what is the purpose of having Form D then?
Absolutely right. I completely agree with you on this point, because see, every time either we have to rely our client, or we have to see that kind of a this thing, because see, we go by, if somebody is going to come to us to file an OC application, we have been very clear, we want them to have all kinds of a communication from the CD and OC kind of a this thing. In spite of it, okay, if there is something the CD has raised, we are not allowing them to go under IBC. On the other hand, if the CD is coming to us, most of the times when the CD comes to us, it was at the final stage. So we have to argue only in the court, stating that there was a dispute and the quality is not good, kind of a this thing. The only rescue for most of us is Mobilox case. If there is a plausible dispute, kind of a this thing. But I completely agree with, I really do not know. See, basically, if you look into CARO 16, which has come, wherein we have to, as a chartered accountants, we have to give so much of details about this. When we are doing it, we are asking them if there is any kind of a notices received during the period, kind of a this thing, then only they are coming forward. And 90% of the promoters are, they are aware of it, but they are not able to understand the seriousness about the NESL demand notice, kind of a this thing. This is what is my understanding. And two areas, when they come to us on time, we were able to raise the dispute, and it was there. But 90% people till date are unaware of this. And second, as you have very rightly said, if it is an and instead of or, that makes lots of difference. And I completely agree with you. And thank you.
Otherwise, this document should not be taken, or if this document should not be the mandatory document for moving such application. Because when we move such application, the registry or the tribunal used to say that please come up with Form D, whatever may be the position it is, whatever may be the status it is, you place on record so that we can go further with the application. So if this document is being part of the mandatory document, then what is the purpose of having this document on record, especially when it is stating that debt is deemed to be authenticated, but still the other side want to demonstrate that there is some subsistence of dispute? It's just a feeble attempt.
Yeah, absolutely right. But ignorance cannot be taken for excused. But this is basically like it is a tough job for the CD's advocates to prove that there is an existence of dispute.
It's a
And
tough
more
job
than
for
that,
it's a more tougher job for the councils of the OC to substantiate that this is just a communication and not the existence of dispute. They get
yeah,
the
see,
benefit of they get
yeah,
the
I am on the
benefit
other
of
side
timely
with the CD.
communication.
See, I am with the CD because if there is a dispute, that's what I'm saying. You are very rightly pointed out. If they receive the notice, they are taking little bit serious. But when it comes to the NESL default reminders, they are not worried about it. Mostly, it goes to the company secretary. Most of the time, the company secretary, I will not say company secretary, it go to the KMP. KMP has to understand this particular area very clearly, and he has to try to do it immediately. See, I have seen a lot of cases wherein there is a dispute, but the dispute was not properly informed the other person at the appropriate time. That
I
is what
believe,
is in most of
furthermore,
the
I
cases.
believe one more thing. It's not only the pre-existing dispute or the communication prior to the receipt of demand notice, but that communication should speak by itself. The mere communication cannot give us an impression, or the mere communication cannot be the only, or the mere communication cannot be a basis of considering that communication is a part of the pre-existing dispute. The dispute should be substantiated as well. The dispute has to be on a speaking term itself. It cannot be just a communication between the CD and OC prior to the service of demand notice or prior to the delivery of demand notice. That communication per se cannot be considered as an existence of dispute unless that communication itself is substantive in nature. That is what I believe.
Yeah, I completely agree with you. I mean, sometimes it's a tough job. Sometimes it's a kind of a this thing where we can definitely
Because many a times
satisfy the
I've seen one
adjudicating
more
authority.
thing. I've seen one more thing. These mandatory provisions of the other statute are also being ignored by the adjudicating authority while dealing into such application when there is a clear smell of creation of dispute rather than existence of dispute. They don't generally go into the provisions of Sale of Good Act. They don't go into the provision of the MSME Act. They don't go into the provision of the Contract Act, because in those act which are actually dealing with the aspect of sell of good or sell of services or sell of product, there is always a time frame within which you are supposed to raise a dispute. It cannot be it cannot be that belated. It cannot be post consumption. It cannot be post making payment. If I am the receiver of a good which is inferior in nature, or which is not, or merchantable in nature, or if I'm in receipt of the services which are being rendered by the other side and which are right now being in question, I must say that I cannot raise a dispute after its consumption and after making its payment. The moment I consume it, the moment the payment is made from my side, it brings an end to that contract which was created out of that cell.
Yes, sir, I completely agree with you.
There is
In one
always a
of my
timeline, and that's why I must say the timeline either is governed by the purchase order, if it is governed by the invoice, if it is governed by any agreement, if it is governed by sale of good act, if it is governed by the MSME Act, those provisions are very relevant for the adjudicating authority to see upon, to touch upon, while dealing into this aspect, especially the aspect wherein the pre-existing dispute is being claimed just on the basis of few communication exchange between the parties, but otherwise the fact is neither those invoices are in question, nor those amount is right now is a subject matter of default, nor those supplies right now being a part of the subject matter of the application. All those invoices have already been settled. All those invoices are no longer a subject matter of dispute. The subject matter of dispute is generally those invoices which are actually unpaid, but they are taking the shelter of those invoices on which they have some communication subsisting, but otherwise those invoices are also settled, and the qualities or the goods are or the products have already been consumed. You cannot take the benefit of making non-payment of other invoices on the basis of those invoices which right now you're relying upon, but you have paid otherwise. Views of other participants is appreciated. In case you have anything to say, please share.
Hello,
Please, sir.
sir. You just mentioned that there were communication between the not between the OC and the corporate debtor, but between the director or partner of the respective companies or respective.
Absolutely, sir.
But sir, tell me one thing that how do they communicate? See, the company is, or partnership firm, whatever it is, it's a artificial entity. So they have to communicate through some individuals who are holding the positions in the company. So how does this? I'm not able to understand.
I'm
They
coming to
have
that.
they have already communicated. WhatsApp is the
No, no,
now
I'm coming
established
to it,
means
sir.
of
I'm
communication.
coming to it. See, we used to say that company being a separate entity or the LLP being a separate entity. Now, Mr. Ajay Gulati ji is a partner of one LLP. Being a partner of the LLP and I being a director of the operational creditor, we are we are communicating, or we are in interaction with each other in terms of the the goods which are being placed for order. You being a consumer to that product, you are raising concern pertaining to the quality of the goods which you have received. This communication is being exchanged between both the parties. For the sake of convenience, we are sending a message over WhatsApp to each other. Now tomorrow, if there is a dispute, or if there is a case of non payment by your LLP to my company, your limited liability partnership, who being a corporate debtor, has failed to make necessary payment, and I'm moving an application against your LLP before the adjudicating authority. But the case is a Vinit Nagar, who was a director in once upon a time when that supply has taken place or when the supply was made. He is no longer a director on the board of this private company who is preferring an application before the adjudicating authority. But you being a partner in the LLP, placing on record and relying on those WhatsApp conversation which was exchanged between you and me, since I am not a person on the board of this company right now, I was holding a directorship few years back. But this concern which you have raised, this quality issues which you have raised to me, that was never communicated by me to my board. Never communicated by me to my board. So, meaning thereby there was never a communication which was sent by your LLP to my company. It was just a WhatsApp conversation between you and me, which was kept on rolling year after year. But you kept on placing order. I kept on making those supplies. You, I kept on raising invoices. You kept on making those payment. But that was concern which was raised by you was never been communicated by me to my board. And today you are placing on record and you are relying upon that WhatsApp conversation which was exchanged between you and me. I have all the reason to state that if there was a communication, or if there was actual a quality concern, or if there was a concern in terms of the quality of the goods I have supplied, then that at that appropriate point in time you must have communicated to the company and not to a single director.
So
Because
like,
I believe my point is, being a separate entity, you, if you have a legitimate say on any subject matter, if you have a legitimate concern pertaining to the quality of the goods which I'm supplying, why the concern has never been raised to the company, and why the concern was kept on raising before a particular director who may not be communicating the same to the company? Why the proper communication was not made to the company is my point. And why this communication was only because I'm talking about a director and partner. Now let's say if this conversation is subsisting between a production manager and a marketing person or a sales person, I at any point in time can say that I have never received any communication from my production manager, or you at any point in time can very well say that this communication has never been made to the LLP. Why only to that, or only with that concerned person? His, he was looking after this sales, or he was looking after this marketing, or he was a account person, or he was an admin person. He was not he was not having any locus, but there was no purpose of having or placing on record the communication with that party who is no longer a party to my operations right now. And that's why my point, when you see the provisions of the demand notice, the provisions of demand notice which clearly states that you need to raise demand notice on the company or to the existing board of directors, and that to the KMPs or the whole time director or the managing director who are looking after day to day affairs of the company. You cannot communicate with any Tom, Dick, and Harry of that corporate debtor or to that operational creditor. So, my point is very limited, that this communication should have been made to the company concern or to the LLP concern or to the entity concern and not to a private individual. That is my concern.
so had there been any group on the WhatsApp communicating to more than one person? So in that situation, what would have been the scenario?
Ultimately that is going to be for the benefit of the CD only, but my question to that mode of communication is quite different, that why not to the company and why to that group or why to that concerned person, because tomorrow they may not be the same person.
But at that time when this was communicated, they were holding the positions either director or KMP or production manager or whatever.
Then whether any action initiated by the CD for not making further orders, not
No, no, I'm
making
not.
payment.
I'm not questioning anything else. I'm just concentrating myself on the established means of communication, which is WhatsApp, which is now recognized by the courts.
This are being considered by the court, but this is being questioned by me, that why it is taken into consideration even. It should be between principal to principal and not to the agent.
See, in a large companies, you don't have director to communicate. No, there are
Not
person.
director. You always have an access to communicate in a formal email ID provided by the company. You
Yeah, yeah,
always have that freedom to communicate in writing to that address where the registered office of the company is situated. Be it be acknowledged by the board of that company or not is a secondary issue. But communication, of course, I'm not questioning the service through WhatsApp. I'm not questioning the communication through WhatsApp. I'm questioning the communication to the OC or communication to the CD. This is my viewpoint. I may be different or I may be wrong on my part, but this is my limited concern, that because such nature of communication keep on rolling when any when any commercial transaction take place. If today me and you are entering into a contract, your employees at your office and my employees at my office will keep on चैनलिंग दोस्त कम्युनिकेशन. आज पेपर नहीं आया, पेपर लेट आया, आज काम होना था, आज काम नहीं हुआ, डिले क्यों हो रहा है, थोड़ा जल्दी प्रोवाइड करें. This kind of communication always form a part of any commercial transaction, but that conversation cannot be a substance of placing on record tomorrow as a part of pre-existing dispute, is my limited point. I have your views. Any other participant, in case if one want to add upon this subject? Let me share with you a discussion paper, mediation for section 9 application. Let me share with you. Is it visible? I hope it's visible. Now, this is a discussion paper on mediation by the operational creditor before approaching the NCLT for filing of Section 9 application. But there is always a debate whether to make it mandatory or whether to keep it voluntary. Because when you see the provisions of the Mediation Act, is a voluntary act of the parties. It's a discussion paper on mediation by the OC before approaching adjudicating authority for filing Section 9. The expert committee on the framework for use of mediation under the IBC, constituted by the Insolvency and Bankruptcy Board of India, submitted its report on January 24. The report suggested a pre-institutional mediation as a preliminary step before filing an insolvency application. Suggestion was also, anyways, this is not so relevant. In light of the recommendation, the discussion paper deal with the voluntary mediation by the OC before initiating an application under section 9 before adjudicating authority. It's a voluntary mediation by the OC before initiating an application under section 9 before the adjudicating authority. There are several recurring issues in Section 9 application, particularly dispute between the OC and CD. And the common issues of these disputes are disagreements on the goods or services regarding quality or performance of the goods and services. So, this is by and large a disagreement on the goods and services regarding its quality or performance of the goods and services. So, basically, in terms of quality, contractual dispute having allegations of non-compliance with the contractual terms by the either party, discrepancies over the exact amount of debt owed or alleged underpayment, claim of CD against OC for set off or damages. These issues are time consuming and eventually unnecessary burden the limited judiciary capacity. And as I said, that the intent of code is not to adjudicate upon such application. The intent of the insolvency and bankruptcy code is altogether different, rather than to sit upon such issues which are more of contractual in nature. In most of the OC initiated insolvency cases, they are more interested in repayment of the money claims rather than admission or resolution of the corporate debt. According to the adjudicating authorities, data up to 30th April 24, 21,466 cases under 9 were disposed of before admission, and only 3818 were admitted. Therefore, a large number of Section 9 cases were settled before admission, and settlement rate of CIRP pre-admission for OC has been larger than any other states. Again, now what has been recommended? So it is proposed to have that an option of mediation can be exercised by the OC before filing Section 9 application. The OC can undergo mediation with the aid of mediator as provided under Mediation Act 2023. In case of failure of mediation settlement, the mediator will prepare a non-settlement report which shall be annexed with Section 9 application. The proposal aims to reduce the burden of adjudicating authority and thereby expediting the admissions. If this things will get adopted, if this will be adopted, I must say many Section 9 application gets early disposal, or Section 9 application, the number of Section 9 application will be substantially reduced. So this is what has been proposed, that to have an option of mediation which may be exercised by the parties, that is an operational creditor and corporate debtor, before OC moves an application under 9 before the adjudicating authority. The OC may undergo mediation with the aid of mediator as provided under the Mediation Act. In case if the mediation fails, this is not adjudication. It's just mediation is nothing beyond facilitating negotiation between the parties. It's not binding कि तुमको ये करना है वो करना है. It's just facilitating communication by avoiding their disagreements and to bring them on table, to bring them on a consensus. In case if the mediation fails, it's the mediator who will prepare a non-settlement report, and that non-settlement report shall form a part of Section 9 application, and this will certainly reduce the burden of the adjudicating authority dealing into this Section 9 applications. Now let me share with you certain provisions of the Mediation Act which is going to help us out to understand that how this mediation is going to be governed. I will only refer to certain provisions. Now, as far as this Mediation Act is concerned, it is very important for us to look after this preamble, this objective, and we will be only dealing into very limited provisions, understanding of which is going to help us out that how this can be a helpful tool for taking care of such issues which are otherwise emerging in every Section 9 application. See, ultimate intent of this particular act is, now when you see this Mediation Act 2023, it was passed in Rajya Sabha on 1st August. It was passed by Lok Sabha on 7th of August, and finally it was notified in the Gazette of India after receiving the assent of President on 15th of September. But anyways, not going into such dates, I would like to see what is the preamble. It is an act to promote and facilitate mediation. Make sure this is not a binding. Not mediator is not binding those parties. He will just promote and he will facilitate mediation, especially institutional mediation, for resolution of dispute, commercial or otherwise, enforce mediated settlement agreement, provide for a body for registration of mediator. We will find Mediation Council of India. That is to encourage community mediation and to make online mediation as acceptable and cost effective process, and for matter connected therewith or incidental thereto. Now what is important is what we are going to see. Now better see clause H, 2 clause H, 3 clause H rather, a definition part, and this is what defining Mediation includes a process, whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or expression of similar import, whether party attempt to reach an amicable settlement of their dispute with the assistance of third person referred as a mediator who does not have authority to impose a settlement upon the parties. Now, this is very important. Who does not have an authority to impose a settlement upon the parties. First, it is always considered as an voluntary act. A process referred by the expression mediation or litigation mediation or online mediation or community mediation, conciliation or expression of similar import. Parties attempt to reach an amicable settlement of their dispute through assistance of third person referred as a mediator who does not have authority to impose a settlement upon the parties. And एक चीज याद रखना, whatever exchange, whatever communicated, whatever has been placed during the course of mediation will stay there only. This shall not come when such section 9 application will be dealt before the adjudicating authority. I'll be dealing into this aspect. This is again important. A person who is appointed to be a mediator by the parties or by mediation service provider to undertake mediation and includes a person registered as a mediator with the council, Mediation Council of India. N is again very important. Mediation settlement agreement means a mediated settlement agreement. When you see party, means a party to a mediation agreement or mediation proceedings whose agreement or consent is necessary to resolve the dispute and includes their successor, meaning thereby this cannot be a forceful process or this is going to be a voluntary act only. Now, pre-litigation mediation is important, which we are expecting to be very soon shall form a part of the IBC through regulation, especially for Section 9. A process of undertaking a mediation as provided under Section 5 for settlement of dispute prior to filing of any suit or proceedings of civil or commercial nature in respect thereof before a court or notified tribunal under subsection 2 of Section 5. It's pre-litigation mediation, and that is what we have seen pre-institution mediation. So before instituting an application, a mediation is a voluntary act between a OC and CD. Through the help of mediator, they will try. There is a time frame which is prescribed. We are going to deal into that aspect. 120 plus 60, that is 180 days time frame, which is provided in the Mediation Act, within which the parties will try to amicably settle the issues. If settlement is not taking place, a non-settlement report will be signed and will be provided to the parties. If settlement arises, there is a settlement agreement. Let us see mediation agreement. This is very important. When you see a mediation agreement, it is in writing by or between the parties or anyone claiming through them to submit to mediation all or certain dispute which have arisen or which may arise between the parties. Mediation agreement may be in form of either a mediation clause in any agreement or it shall form a specific agreement itself, just like an arbitration. Either ये एक कॉन्ट्रैक्ट का क्लॉज हो or else it can be through a specific agreement itself. A mediation agreement is in writing if it is contained in or recorded as any document signed by the parties, exchange of communication or letter including electronic form, any pleadings in suit or other proceeding in which the existence of mediation agreement is alleged by one party and not denied by other party. A reference in any agreement containing a mediation clause shall constitute a mediation agreement if the agreement is in writing and reference is such that as to make the mediation clauses part of agreement. कब माना जाएगा that there is a mediation agreement? Now this is very important. If you see clause 5, very important. The parties may agree to submit to mediation any dispute arising between them under an agreement, whether this agreement is entered prior to arising of the dispute or subsequent thereto, meaning thereby such an agreement can be entered into between parties even after the existence of dispute or after the dispute has been arised between the parties. This is very important. that party may agree to submit to a mediation any dispute arising between them under an agreement, whether entered prior to arising of dispute or subsequent thereto. This is very important. And this clearly gives us an impression that this kind of agreement may be entered into by and between the parties even after the dispute is arising amongst them. So parties may agree to submit to mediation any dispute arising between them under an agreement, whether entered prior to arising of dispute or subsequent to. Let's see pre-litigation mediation. This is very important, which we have already there in 12A of the Commercial Code Act 2015. Subject to other provisions of this act, whether any mediation agreement exists or not. अगर ऐसी चीज अगर आ गई तो in the IBC, the parties before filing any suit or proceeding of civil or commercial nature in any court may voluntarily and with the mutual consent take step to settle the dispute by pre-litigation mediation in accordance with the provisions of this act. Provided that a pre-litigation mediation in a matter of commercial dispute of specified value shall be undertaken in accordance with provision of section 12A of the Commercial Court Act. I'm not going into it, but this is what the government is thinking to bring it in this the insolvency and bankruptcy code, that subject to other provisions of this act. Now this is what we are reading, the mediation act, where any mediation agreement exists or not, the parties before filing any suit or proceedings of similar commercial nature in any court may voluntarily and with mutual consent take step to settle the dispute by pre-litigation mediation in accordance with the provisions of this act. Section 7 is also very important, which states that notwithstanding the non-settlement of dispute under subsection 1 of section 5, this is unfortunately missing in the insolvency and bankruptcy code, but otherwise you will also find this in the Companies Act. अब जब Companies Act के provision देखेंगे, so there is a provisions in the Companies Act section 442, but unfortunately this provision is missing in the insolvency and bankruptcy code. Otherwise, if there is any provision subsisting in the code, then in that case, notwithstanding the non-settlement of dispute under 1 of section 5, the court or the tribunal may at any stage of the proceeding refer the parties to undertake mediation. Section 7. If the court or tribunal refer the parties to undertake mediation, it may pass suitable interim order to protect the interest of any party if deemed appropriate. The party shall not be under an obligation to come to a settlement in the mediation. So there is no such obligation on any of the parties that they are bound to reach to a settlement. If settlement fails, always it's a court or tribunal who is going to deal upon the dispute. But otherwise, if these things will get introduced in the code, and if the adjudicating authority is empowered, then in that case, at any stage of the proceeding, they may refer the parties to undertake mediation. This is important. Section 13 is again very important. Every mediation under this act shall be undertaken within the territorial jurisdiction of the court or tribunal of the competent jurisdiction to decide the subject matter of dispute. Now, this is dealing into the aspect of the jurisdiction. That mediation under this act shall be undertaken within the territorial jurisdiction of the court or tribunal of competent jurisdiction to decide the subject matter of dispute. And in the IBC, that competent jurisdiction is the court, is the tribunal within whose jurisdiction the registered office of the corporate debtor is situated. So it depends upon where the registered office of the corporate debtor is situated. That is going to be the territorial jurisdiction wherein this mediation process will be conducted. The mediation shall be undertaken within the territorial jurisdiction of the court or tribunal of the competent jurisdiction to decide the subject matter of dispute. But it is also provided that on a mutual consent of the parties, the mediation may be conducted at any place outside the territorial jurisdiction of court or by the way of online mediation as well. But it is clearly explained that It is clarified that where the parties agrees to conduct a mediation at any place outside the territorial jurisdiction, or if they decide to opt for an online mediation for the purpose of enforcement or to challenge and registration of the mediation settlement agreement, the same shall deem to have been undertaken within the jurisdiction of the court or tribunal of competent jurisdiction. Commencement, we can read when it will be considered as if it is commenced. The mediation proceedings with respect to a particular dispute shall deem to have been commenced where there is an existence, where there is an agreement subsisting between the parties to settle the dispute through mediation. The date on which the party or the parties receive a notice from the other party initiating a mediation or to refer the dispute to a mediation. And in other cases, so the cases where there is no agreement existing, or where the parties have agreed to appoint a mediator of their choice for mediation and settlement of dispute between them on that date, the mediator provides consent. Where one of the parties apply to a mediation service provider for settlement of dispute, then through mediation, then date of appointment of mediator by service provider. Now, there is very important. There is a provision which clearly states that if there are more than one parties, let me reach out to that provision. Now, this is very important. If you see timeliness, which is provided in section 18 and 19, these are very important. I've seen many of the cases wherein a corporate debtor claims that because of the nature of the quality of the goods been supplied, or because of the nature of the quality of the products which has been supplied by the operational creditor, my client has suffered a damages. My client has suffered a loss. And I have received this communication of this loss from a third party. So basically, I, being an operational creditor, has made some supply to the CD. The CD which has used that particular product as a raw material or as a part of ingredient in that process, and the third party has suffered a loss or an injury, and it is the third party which has raised a dispute, or which has raised this concern or raised an issue before the corporate debtor, and corporate debtor, on the basis of that communication, is they used to try to establish a pre-existing dispute. Please listen it very carefully, because this is very important. Timeline: notwithstanding anything contained in any other law for the timing in force, a mediation under this act shall be completed within a period of 120 days from the date fixed for the first appearance before the mediator. It is not calculating from the date of commencement of mediation, but it is an appearance, first appearance before a mediator. The period of mediation under subsection 1 may be extended for a period of 60 days if it is an agreed by the parties. Though this is 18, but 19 is very clear. A mediation settlement agreement includes an agreement in writing between some or all the parties. So there is a possibilities of having more than one parties in that mediation process. A mediated settlement agreement includes an agreement in writing between some or all of the parties resulting from mediation, settling some or all the dispute between such parties and authenticated by the mediator. Meaning, thereby, if the mediation has taken place and there were three parties, one who was the supplier, the operational creditor, the other one who was the buyer, that was a corporate debtor, and that was some third party. Now, based on the concerns which is raised by third party to before the CD, it now CD who is trying to bring a dispute in the process of the section 9 application which is initiated by the OC. Now, point is, if through a mediation process, if all three parties reach out to a consensus that nahi, there was not an issue, or it is not attributable to my goods or my product, but it was somewhere an issue on the part of the CD, leading to which that third party has sustained a loss or damages, or that loss has been caused to the third party. For example, I've experienced a case wherein I was a OC. I supplied some material to the CD, and CD was into the business of waterproofing. And some sort of waterproofing work was undertaken by the CD at one club. कोई क्लब था, कोई amusement park था, wherein the CD has undertaken some a contractual work, and I was the supplier of some waterproofing product. I was a supplier of some waterproofing product based on the communication which CD has received. I said, based on the communication which CD has received from that club or that amusement park, when I moved a Section 9 application before the adjudicating authority, the CD placed on record that communication which it has received from that club or amusement park. Now, I must say that if the provision of mediation is brought into the code of, or if there's provisions of the mediation, if it shall form a part of this insolvency and bankruptcy code, then it is not mandatory that some consensus is reached between me and the corporate debtor, but there is always some consensus which may be reached between the OC and that third party. So this is section 19, which is very important, that a mediated settlement agreement includes an agreement in writing between some or all the parties resulting from mediation, settling some or all the disputes between such parties and authenticated by the mediator. Now this is section 19, where a mediation settlement agreement is reached between the parties with regards to all or some of the dispute. The same shall be reduced in writing and signed by the parties. Subject to the provision of 26, a mediated settlement agreement signed in case of institutional mediation. Anyways, this is not something I'm touch upon. 21 is again very important. That what in case if no what in case if no settlement takes place even after the initiation of this mediation process, or even after opting for a mediation process, in case if no settlement take place, then non-settlement report is required to be submitted before the court. And in our case, if the provisions of this mediation, if brought in the insolvency and bankruptcy code, then nothing. But in such section 9 application, non-settlement report shall form a part of such application. Subject to the provision of 26, where no agreement is arrived at between the parties within the time period as provided in section 18, or where the mediator is of the view that no settlement is possible, then he shall, in the event of institutional mediation, shall submit a non-settlement report to the mediation service provider. In other cases, they prepare a non-settlement report and provide a signed copy to the parties, provided that the report referred in this section shall not disclose. Now, this is very important. This is very important because many of the participants, they they must be assuming, or they must be presuming, or they must be thinking that this mediation process will give a rise to another sort of litigation. That means in every process wherein the mediation has taken place, it is always considered as a case of pre-existing dispute. No. And as I said, that the report referred to in this section shall not disclose the cause of non-settlement or any other matter or thing referring to their conduct during mediation. Kuch bhi nahi. It is simply a report which will state that whether any settlement took place or not. So the report referred in this section shall not disclose the cause of non-settlement or any other matter or thing referred to their conduct during mediation. This is important. And when you see section 22, which deals with confidentiality, very important. Subject to other provisions of this act, the mediator, the mediation service provider, the parties and the participants in the mediation shall keep confidential all the following matters relating to mediation proceedings, namely acknowledgements during the process of mediation, opinion during the course of mediation, suggestions, promises, proposals, apologies, admissions, everything which will form a part of that process shall remain confidential. And it is the mediator who need to keep these things confidential. It's a duty on the part of mediation service provider, which we are going to see in the time to come. The parties and the participants in the mediation shall keep the things confidential, namely all the acknowledgements during the course of mediation, opinion framed or rendered, suggestion received, suggestion exchanged, promises made, promises exchanged, proposal made, proposal received, apologies given, apologies received, admission made, admissions given, all things remain confidential. Acceptance of or willingness to accept proposal made or exchanged, document prepared solely for the conduct of mediation, that shall remain confidential, and duty shall be on a part of the mediator and the participant to keep these things mediate, to keep these things confidential. And it is also provided that no audio or video recording of the mediation proceeding shall be made or maintained by the parties or the participants, including mediator and the mediation service provider, whether conducted in person or online, to ensure confidentiality of the conduct of mediation proceedings. Subsection 3 clearly states that subsection 3 of 22, that no party to the mediation shall in any proceedings before the court of tribunal, including arbitral tribunal, rely on or introduce as evidence any information or communication set forth in 1 to 4 above, including any information in electronic form or verbal communication, and the court and tribunal, including arbitral tribunal, shall not take cognizance of such information and evidence. This is very important. When it shall be considered as if the mediation is terminated, section 24. The mediation proceedings under this act shall be deemed to be terminated on the date of signing and authentication of mediation settlement agreement. Good, there is no question of section 9 application. Or on the date of the written declaration of the mediator after consultation with the party to the effect that further efforts at mediation are no longer justified, or on the date of communication by the parties in writing addressed to the mediator and other parties to the effect that party wishes to opt for the mediation, out of the mediation. So meaning thereby these are the four circumstances wherein it will be considered the mediation is terminated. One, on the date of signing and authentication of mediation settlement agreement. Good, अगर agreement reach हुआ है, settlement reach हुआ है. B, on the date of the written declaration of mediator after consultation with the parties to the effect that further efforts at mediation are no longer required. On the date of communication by the parties in writing addressed to the mediator and the other parties to the effect that party wishes to opt out of the mediation. And the fourth one is on expiry of the timeline, which is provided 120 days from the date of first appearance before the mediator. 27. Enforcement of mediation settlement agreement. A mediation settlement agreement resulting from mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and person claiming under them respectively, and enforceable as per the provision of subsection 2. Very important. There is always a question in the mind of the participants that what about the limitation period, and that's why this is what provided in section 28 or 29. Notwithstanding anything contained in the Limitation Act or in any other law for the timing in force, in computing the period of limitation fixed for any proceedings relating to dispute in relation to which the mediation has been undertaken under this Act, the period from which the commencement of mediation under 14 and up to the date of submission of report under 21 or termination of mediation under 24, this duration shall be excluded. Now, this is very important because if there is a concern pertaining to expiry of the limitation period, then in that case section 29 is making it clear that notwithstanding anything contained in the Limitation Act 1963 or in any other law for the time in force, in computing the period of limitation fixed for any proceedings relating to dispute in relation to which the mediation has been undertaken under this act, the period from which the date of commencement of mediation under 14 and up to the date of submission of report under 21. Under 21, we have seen it is a report which was submitted by the parties, and that is a non settlement report. So, up to that date, or in case if it is terminated, termination of mediation under 24, termination will take place if some settlement is reached, if settlement is arise, and that is what we have seen in the provision of section 24 very recently on the date of signing and authentication of the mediation settlement agreement. So from the date of commencement of mediation procedure up to the date of submission of report, that is a non-settlement report, or up to the date of termination under 24, that period which will be excluded if you are concerned about the timeliness of filing that application, otherwise it will be barred by limitation. Make sure the time from which the mediation is commenced, date of commencement of mediation up to the date of submission of non-settlement report, or up to the date of termination of mediation under 24, this timeline shall be excluded. So I believe as far as section 9 is concerned, the discussion paper is of the same opinion. There is a report as well, there is a report as well, the report of the expert committee which deals with, and that report you can find January 2024 report, expert committee constituted by the IBBI, and there is a report on the framework for use of mediation under the IBC. It is of 31st January 2024. When you will see the report, you will find this thing, that there is no provision which mandates parties or which bind parties or which put the parties under an obligation to opt for a mediation. It's a voluntary process. It's a voluntary process and you cannot made it mandatory. But let's see how it is going to be introduced in the IBC. That in section 9 application, before you move section 9 application, you should invoke IBT, you should invoke the mediation. If no settlement is reached, no consensus is reached, non-settlement report shall form a part of section 9 application. If settlement is reached, ultimately it will serve the purpose for which it is brought into the framework of the code. I will appreciate your views on bringing this mediation, pre-institutional mediation or pre-litigation mediation, what we see in the Commercial Court Act, especially in section 9 application. Your views, please.
Sir, how does this differ from Arbitration Conciliation Act?
See, arbitration is altogether a formal procedure wherein the arbitral award is being passed, binding in nature, mandatory to follow that procedure. As far as the mediation is concerned, the role of mediator is not basically to bring, ultimately, what is an objective of this mediation act is, if I or you being a mediator, we are not going to suggest anything or we are not going to put any binding. See, when you will see an arbitration award, there is nothing like an award or there is nothing like an order being passed by the mediator, unlike in case of arbitration. Mediator will simply place a role of bringing the parties on table. I've seen many of the section 9 application, it is very much a case of a clash of ego amongst them. OC through its counsel, OC through its relative, OC through its OC through its common relatives is trying to mediate, as is trying to communicate, but OC is not directly communicating with the CD, and same is the problem with the CD as well. They wish as so, one is waiting for other to initiate, and that is what the role of mediator would be. Mediator is not going to bind anything on them. Mediator will simply facilitate the communication amongst them. Mediator will be trying its best endeavor to bring the parties on table. The role of mediator is just to be a forum, to be a mechanism, to be a facilitator of exchanging the communication between the OC and CD. And he will not try, he is not going to adjudicate on the dispute, he is not going to review the dispute, he is not going to go into the merit of dispute, or he will not be proposing any terms of you can say dispute settlement. He will simply act as a part or a facilitator of that communication. ये सच है, ये गलत है, ऐसा होना चाहिए था, ऐसा हुआ, जो आर्बिट्रेशन में होता है.
Mm-hmm.
See the arbitration, or when you see the arbitral award, who is right, who is wrong is not something. A mediation process is all about. A mediator has to play its role. Mediator will limit its scope. Mediation process, or the mediator will limit its scope. He is not going to be an adjudicator. He is not going to be a judge. He is not going to decide upon the case. He is not going to decide who is right or who is wrong. He is simply going to be a facilitator who will bring the parties on table. He is not going to say that नहीं इसमें ऐसा होना चाहिए था but फिर भी ऐसा हुआ and better है you should settle at this place. No, आपके जो भी disagreements हैं, face each other, try how you can able to, and to actually explain what in case if the applications get admitted. Because you know, when section 9 applications get admitted, the biggest loser would be that OC only,
Correct.
at least for that 1 month for which he need to bear the expenses, or for that he need to bear the fees of that
Mediate.
insolvency professional who gets appointed as an IRP. And later on the COC will decide up to what amount the IRP expenses and fees to be ratified. So this is what the scope, or this is what the role of mediator would be. He will not be acting as an arbitrator. He will simply act as a mechanism, a facilitator, so that communication gap which is subsisting between both the parties should be avoided.
So what does then settlement if the parties reach settlement? So
If
what
parties
we say the parties have reached settlement. That's all. Nothing more than that.
Absolutely. So matter will not reach to the NCLT, and NCLT can able to focus on certain resolution plan which are hanging since years.
Okay. Thanks. Thanks.
Anything else? In continuation to your last point, let us see section 16 of the Mediation Act. Referring to our ongoing discussion, let's see the scope or the extent up to which the person will be section 16 of the Mediation Act 2023. The mediator shall attempt to facilitate voluntary resolution of dispute by the parties and communicate the views of each parties to other to the extent agreed to by them, assist them in identifying the issues, advancing better understanding, clarifying priorities, exploring areas of settlement, generating opinion in an attempt to resolve dispute, emphasizing that it is the responsibility of parties to take decision regarding their claim. Parties shall be informed expressly by the mediator that he only facilitated in arriving at a decision to resolve a dispute, and that he shall not impose any settlement nor give any assurance that mediation may result in settlement. Mediator shall not act as an arbitrator. Section 17. He shall not act as an arbitrator or representative or counsel of a party in arbitral or judicial proceeding in respect of a dispute that is subject matter of mediation proceeding. Mediator shall not be presented by the parties as a witness in any arbitral or judicial proceeding. So this is the limited scope which mediator has to follow or which mediator need to pursue. Attempt to facilitate voluntary resolution. Communicate the views of each parties to the other to the extent agreed by them. To the extent agreed by them. जो पार्ट पे एग्री नहीं है वो बातें नहीं करनी है. Assist them in identifying the issues, advancing better communication, clarifying priorities, exploring the areas of settlement, generating opinion in an attempt to resolve a dispute, emphasizing that it is the responsibility of parties to take reason about their claim. He will not enforce them to enter into any settlement agreement. Yes. If there is any views to exchange, if there is anything to discuss, if there is any query or concern pertaining to the subject matter of discussion, we'll address the concern. Therefore, I am of the opinion that this should somewhere bring within the regime of the code. It should form a part of the regulation. IBBI, insolvency resolution process for a corporate person's regulation. It should form a part of it, especially for Section 9 application, because many Section 9 applications are hanging before the adjudicating authorities in all the benches across India. Enormous time is being consumed by and between the parties on the grounds of settlement. Ultimately, no settlements are being reached, matters are being admitted, and many Section 12A applications are being filed for withdrawal. If this mediation will be brought in within the framework of the code, you will find a reduction in number of Section 9 application, and you will find more reduction in the number of Section 12A application for withdrawal of those applications which are admitted. So I believe that somewhere it should be brought in within the code, and let the mediator plays a big role, and there has to be some, in every court there is a mediation cell. You'll see district court, you'll see high court, there is a panel of mediator. So similar things should be brought in within the purview of the NCLT. NCLT should have a panel of mediators. There's a mediation center at NCLT, or there should be some impaneled mediator, and out of those impaneled mediator or through the mediation process, such Section 9 applications get early resolution, early disposal. Only in case of non-settlement report, the applications get adjudicated by the adjudicating authority. But during that course, no settlement or no adjournment on the ground of settlement should be allowed. Or there should not be any extension to any pleadings like we have in the process of Section 9, Section 7. We do have an application, then reply, then rejoinder, then there is sir rejoinder, then there is a rebuttal to that sir rejoinder. So when we say it is a summary proceedings, then in that case the pleading should not be extended to this. As I said in my application, in my case, which went against me, before a date of final hearing, we have received an IA, and in IA some additional documents were placed on record, which has never been exchanged between the parties at the time of reply, or it was not a part and parcel of any communication which was subsisting till that date of application before the adjudicating authority. So I believe that if we see IBC in true sense, the adjudicating authorities are not mean to go into the merits and demerits of the disputes, and make sure if there is a differences or in case if there is a disputes between the party, let them amicably settle. If there is no successful mediation, then in that case section 9 application should be supported with that report of mediator mentioning no settlement agreement, and then such application be decided by the adjudicating authority. I believe if these things will be brought in within the framework of the code, section 9 disposal will be high, and there will be very less number of section 9 application which will be considered as pending before the adjudicating authority, and the consequences thereof, section 12a application will be reduced to a much extent. So I believe this is something which should be brought in, through which the mediation act can be tested in the code. If there is something to discuss about, I'll be appreciating your views, appreciating your question. In case if there is nothing to discuss further, I would like to conclude the session.
So who can be these mediation providing persons providing mediation services?
See, in the Mediation Act, it is not fully enforced, but there is a provision of mediation service provider. So, and there is a provision of Mediation Council of India as well. So, the mediation service provider will be having this facilities of getting empaneled as a mediator. And as I said, in the court, there is always a panel of mediator, a mediation cell, wherein certain persons have enrolled themselves as a mediator in that cell. And it is the mediation which is processed through that cell. So I believe, and in the Companies Act also, you will find the provision of mediation and conciliation panel 442, wherein the regional director comes up with the requirement of, you can say, they invite expression of interest from the professional who fulfill the criteria of eligibility. They themselves can get themselves enrolled with that list of mediator being empaneled with the regional director. So I believe at this moment, I must say, in the code how they are going to bring in. But yes, till date I have not seen or I have not heard about the Mediation Council of India been established or mediation service provider been established or working. But the moment this thing will process, the Mediation Act will, it is the solution which will be brought in, or these things will be processed through the 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 you can say the early enactment of the Mediation Act. Who can be a mediator right now? This is in question. What is going to be the criteria? What is going to be that education course? What is going to be the training structure? Everything cannot be answered at this moment because there is no such rules or regulation which are existing even in the Mediation Act.
Okay.
May we conclude? Thank you, Institute, for giving this opportunity to have this interaction with all the learned participants, and I look forward for many such interactions as a speaker, as a participants, and this is going to value add to this profession. Thank you very much.
Thank you, sir. On behalf of Team ICSI IIP, I would like to extend my sincere thanks to you for taking out time and addressing session for workshop on the topic pre-existing dispute and need of pre-institution mediation in Section 9 matters. Thank you for sharing your experience and learning and making the session interactive and insightful. Thank you.
Thank you. Thank you.
अब सब सेशन कंप्लीट कर, अब नेक्स्ट सेशन 2 बजे से है.
Do we have a break now, ma'am?
यस मैम, यस सर. अब
Okay,
नेक्स्ट
thank you.
सेशन 2 बजे से है.
ठीक है, thank you.
So you mean to say that 2 o'clock?
यस.
Thank you.